my lords, my lady, I was going to return then to the riveting contents of Article 8 of the transitional provisions. Just to finish off this particular part, we are well advanced in a further written submission, which we'll get to the court before the close of business today, but I just need a little bit of time after we finish just to tidy it up. The only reason I come to these further provisions is that these are relevant to the argument that my learned friend and indeed Dr. Thomas made about the retrospective aspect of the legislation by the back door, as it were. And this really puts to bed that argument, because what Article 8.3 is
which one? The revised one?
The new one, yes. The new one is that is...
Just remind me of the...
page number?
1797.
1797. Yes.
This is in relation to the calculation of benefit, and should be read in accordance with Section 223(5) and 2232(b). And also...
So it's lifestyle, basically.
It's a lifestyle, but it says it must not take into account benefit from conduct constituting an offence mentioned in Section 2235(c), which is benefit from conduct which constitutes an offence which has been or will be taken into consideration by the court in sentencing the defendant for an offence mentioned in paragraph A or B, so that in dealing with the confiscation, the court and the decision as to whether there's a lifestyle, the court cannot have regard to pre-2003 offences taken into consideration. That's 8.3. 8.4 and 8.5 deal with a Section 2233(b) situation, which is a criminal lifestyle established by conduct which, in the period of 6 years, ending with the day in which those proceedings were started, or if there were more than one such day, the earliest day, he was convicted on at least 2 separate occasions of an offence constituting conduct from which he has benefited. And 4 and 5 deal with the fact that the conduct and the benefit in that and that specific situation only can be taken into account where there's a pre-2003 offence. And of course that would be because the conviction and the offence have been dealt with in separate proceedings dealing with the pre-2003 offence. So it's only in those very, very specific situations where pre-2003 can be taken into account. And Section 8.6 is necessary in relation to 2232(c), because otherwise pre-2003 offences taken into consideration may have been taken into account when looking at 2236, 2232(c) and 2236(b. And I know that's all rather a mouthful, as it were, but we'll set it out in the additional written submission. And it's really just to show that the net result of all of that is this, that other than in the very specific conditions set out in 2233(b), previous offences cannot be taken into consideration, or benefit cannot be taken into consideration. That's previous to 2003 offences, or benefit cannot be taken into consideration in the determination of whether there is a criminal lifestyle. That was the criticism, or one of the criticisms that Dr. Thomas made, but in fact it cannot do that. It can, of course, if a criminal lifestyle is established, take into account any criminal conduct whenever that conduct may have been committed, and any benefit whenever that benefit may have been received. So I hope with some trepidation that helps to explain the machinations of Article 8. It also is called in aid by me in my argument that the appellant's contentions are incorrect. So
just say it again, Slady. You say that you cannot take it into account in determining whether there is a criminal lifestyle in general, but once you've determined there is a criminal lifestyle, you can go back indefinitely.
Well, exactly, because that's dealt with, my Lord, just for completeness, in 2242, where general criminal conduct, which is what one considers when a criminal lifestyle is established, is it's 2242 says general criminal conduct of the defendant is all his criminal conduct, and it's immaterial whether conduct occurred before or after the passing of this Act, and whether property constituting a benefit was obtained before the passing of the Act. So once criminal lifestyle is established, general conduct is considered, and another important aspect, or general conduct is considered, and that is the whole door is open to the court.
Now, just spell it out. Why do the various provisions that you've drawn attention to demonstrate that when you're looking at 156 and the trigger for confiscation,
Yes.
one's looking at the offences in respect of which the application is made by the Crown?
Yes, that's supportive of all of that argument in my submission.
Why?
Because when one looks specifically at Article 2233A,
2233A, yeah.
specifically saying that conduct forms part of a course of criminal activity, the defendant benefit from the conduct, and in the proceedings in which he was convicted of 3 or more of other offences, each of 3 or more of them constituting conduct from which he has benefited other offences other than the offence or offences concerned. That's supportive of that, and also that there wouldn't have been any need to exclude that from the pre-2003 benefit, because that's the conviction of the offences. Because if the appellant's correct, one never gets to that stage.
Yeah.
So I was going to, as I say, that took me out of my way. I'm going to go back to set my general stall out. Unfortunately, I might repeat some of what I've said, but I'll hopefully try to avoid that. I know that the court would not thank me for it. But as your lordships will see, there really are 3 principal submissions that the respondent makes. First submission is that the meaning of the legislation is clear, and that no words need to be read into the legislation as suggested by the post-2003 case law, relying on the pre-2003 case law. So that's the first submission. If we are correct on that, there's no need to consider the other submissions. The second submission is if we are wrong about that, then the words should be read in to be given purpose of meaning in the to the legislation as described in the case law. I'm not going to spend very much time, if any, on that because it's dealt with in the case. And the third, slightly what might be called the fallback position would be that we say that the provision is in any event only a procedural one and isn't substantive, and therefore in line with Secon and McKnight, it should not defeat the aims of the criminal justice system, which is to have confiscation proceedings in relation to offences that were committed after 2003. I do, of course, accept that it is substantive if a prosecution seeks to proceed in relation to a pre-2003 conviction, because that is expressly prohibited. But it is, however, I say, procedural if the prosecution is seeking to pursue confiscation in relation to post-2003 convictions, because there were other procedural bases upon which that could have been achieved. And my lords and my lady touched on these before lunch, such as issuing 2 indictments would avoid this situation, or simply not proceeding with a pre-2003 offence prosecution in the first place. So those are procedural bases upon which the same result could be achieved. But before I go, as I say, I'm going to focus nearly the entirety of my submissions on the first point. And before I do that, just wanted to point out what we say are the fatal flaws in the appellant's arguments. I've already touched on Article 8, and Article 9 is also called in aid with the prosecution. I'll come on to look at that in some detail. But the second fatal flaw is that the appellant's argument is predicated on the assumption that the prosecution and the court must proceed to confiscation in relation to all of the offences in the proceedings in respect of which there is a conviction. I say that's plainly incorrect. A very simple example demonstrates that, using the situation where someone is convicted of an assault and a robbery, which we discussed before lunch. Why on earth would the court or the prosecution have to proceed to confiscation proceedings in relation to the assault? If there was a conviction for an assault only, there'd be absolutely no question of the court deciding it was appropriate to have confiscation proceedings. The prosecutor certainly wouldn't be asking the court to do so. So why should it be any different? Simply because it's mixed up with a confiscation type conviction. Also, we say the appellant's argument is flawed because it fails to recognise that the phrase an offence or offences has a narrow confiscation meaning rather than expansive meaning. And we say this is clear not just from the language of section 156(1), 2 and 3, but also section 1569, which my learned friend called in aid of his argument. What we say is that the offence or offences within section 156 are only the offence or offences in respect of which confiscation is sought. And we say that there's further confirmation of that can be divined from section 2243b, which is the one that was debated in relation to Article 9, and I will come back to that. We also say that the argument that the prosecution's position makes the act retrospective doesn't stand up to scrutiny for the reasons I've pointed out in relation to Article 8 of the transitional provisions. And before looking at all of those issues in more detail, maybe some general comments I would like to make. First of all, and as my learned friend has already pointed out, the Court of Appeal in Northern Ireland did not consider the implications of section 156, 1, 2, 3 and 9, nor did it consider sections 223 or 224 or Article 8 or 9 of the transitional provisions. That is not a criticism of the court, because it's quite clear those matters were not argued before by the prosecution, and therefore the fault for that lies with the respondent. Nor did those provisions or their English equivalents seem to have been considered in any of the cases within the bundle of authority, such as Stapleton. It didn't carry out any analysis of these provisions. All that the Courts of Appeal to date seem to have done is to say, well, before 2003, that this was the way this was dealt with, and that's the way we'll deal with it now. But if, in my submission, if they'd carried out a proper constructive analysis of the legislation, they would have realised that there was no need to go to this resort of reading in words to the statute. So that's one general comment. Second general comment is, in approaching the case, I suggest the court must give a purposive meaning to the legislation. And in this case, the purposive meaning is very simple, and it's very clear, and it's unambiguous, because the purpose of the provisions was to catch post-2003 offences and to ignore pre-2003 offences. That was the purpose of it. It was to mean that 2002 Act was applied to offences committed after the date set out in March 2003, but not to deal with offences that were committed before it. Just as simple as that. And thirdly, I say it could not have been the intention of Parliament that jurisdiction under the 2002 Act should have been decided by the procedural basis upon which the prosecution proceeded, rather than the date on which the offence was committed, because that, as in effect, would be the result if the appellant's argument was correct. So, with that as the background to it, I think I would suggest, my lords, the best thing then is to look to the Act itself, starting with section 156 and Article 4, and reading them together. And our submission is that section 156 is only applicable if, in fact, a confiscation order is sought, and a plain reading of it makes that clear. So we start at 156.1, which is, we're at page 986, my lord and lady. Starts with the direction that the Crown Court must proceed under the section if two conditions are satisfied. The first is that the defendant falls within either of the first two paragraphs. A, he is convicted of an offence or offences in proceedings before the Crown Court. And B, he is committed to the Crown Court in respect of an offence or offences under section 218 below. Pausing there, it is in my submission of high significance that the same phrase offence or offences is used in both 2A and 2B. And my learned friend has conceded that in relation to 2B, the offence or offences or a lesser figure or a lesser sum than all of the offences or offences of which the defendant was convicted in the magistrate's court. And he seeks in some way to differentiate that from the offence or offences mentioned in 2A. So that's the first thing. Offence or offences is a phrase repeated throughout the Act, and in my submission it must have the same meaning throughout, which is not all of the offences, but just the offence or offences that are subject to confiscation. But further support for that is found in the fact that one then has to go to the second condition, and that is that the prosecutor asks the court to proceed under this section for an offence or offences, or the court believes it is appropriate for it to do so. So it is only, the offence or offences are only relevant insofar as they are made the subject of a confiscation process by virtue of Article 1.3. And then one goes on to Article 4, dealing with criminal lifestyle, which I don't need to deal with just at the moment. But then Article 1569 says references in this part to the offence or offences concerned are to the offence or offences mentioned in subsection 2. In other words, that offence or those offences in respect of which a confiscation order is sought. And when one brings all of the...
Well,
Sorry, my lord.
that doesn't follow, because that amounts to saying reference to the offence or offences concerned as the offence mentioned in subsections 2 and 3.
Apologies, Lord, no, because subsection 2 is related to subsection 3. Can't be. If it's just subsection 2, one never gets to a confiscation situation. It has to be two tests, two conditions have to be satisfied.
Yeah.
So it has to be read in the context of the entirety of the section, not just limited. Yes, subsection 2
I think
can be referred to.
you are accepting that it must be referring to subsection 3 then, if it refers to the entirety. You have to read it in the entire context.
No, the offence or offences have to be read in the entire context. That's the point.
Is the alternative reading of 1562, it isn't focusing really on the offences or offence. It's focusing on the defendant and how he got there. And he's before the court under 2 for one or other of two reasons, either because he's been convicted and he's therefore got to be sentenced and dealt with, or because he's been committed and he's therefore got to be sentenced and dealt with. Yeah. Is that an alternative?
Well, that's another way of presenting the argument, I think, my lord, yes.
Is it? But if you see, if it's
Yes.
focusing simply on the presence of the defendant with the relevant qualifications, it may not carry the implication for which you contend that the offence must be one in respect of which the Crown seeks confiscation.
Yes, but the Crown can only seek confiscation for an offence or offences. It cannot seek confiscation for something else.
And in respect of 2B, it's got to be seeking it, otherwise it wouldn't be there.
Yeah.
Yes, I see.
But if one used my lord's example, if it is he is convicted in say for example he's convicted in proceedings before the Crown Court, obviously that wouldn't have any prohibition on proceeding on post-2003 offences when looked at in context with Article 4.
Well, another way of looking at it might be, if you're focusing on the defendant, it's not simply on the defendant, it's the defendant who has a certain status. Yes. And the status is that he's convicted of an offence or offences.
Yes.
And that's when the narrow connotation of offence or offences, you say, comes in.
Yes, and when one goes to Article 4, all Article 4 is prohibiting is this process being carried out in relation to an offence or offences that have been committed prior to 2003. It doesn't prohibit the process being embarked on an offence post-2003.
Can you help me with the second condition?
Yes.
It narrows down the people to whom this
Yes.
will apply. It's not just the man with the assault conviction, for example. Where do you get the test that the prosecutor applies or that the court applies to decide if it believes it's appropriate?
I don't think that one gets it anywhere.
So how does the court know when it's going to be appropriate? Is there any guide from the context in the statute?
Well, presumably it's because the court has identified within the conviction that there is a possibility there's been a benefit. Because the court would be unlikely to embark upon it if there was no prospect of a benefit. Why would it do it? Because it could, of course, embark on the procedure, but it would end up in a negative result because no benefit would ever be established. So
it's looked ahead to do a sort of provisional assessment as to whether this might be a confiscation order case and decided it is.
in practice, I think, of course I'm not sure, but I think that it's nearly always done because the prosecutor asked the court to do so. And the prosecutor obviously would be thinking ahead. Very often the decision has been made long before the case is even concluded in terms of whether it's conviction or acquittal. Papers are prepared so that they can be served immediately upon a conviction if it's a trial. So,
I asked the question because it rather circumscribes the situation in the way that you're describing, makes it confiscation situations.
it only becomes confiscation when either of those two things happen, because it's not confiscation before that.
But you say that Section 156(2) is only referring to potential confiscation cases. It's not referring to assault cases at all. And in relation to Section 156(9), that has the strength, I suppose, that the phrase offences concerned would be rather odd if it was referring in this sort of statute to, for example, assaults. One would expect it to be focusing on the things which are going to be the subject of a potential confiscation order at the very least, if not an actual one, in view of subsection 3 being operated.
What I'm suggesting, in fact, Lord, that is absolutely right, is that the reason for subsection 1569 is to say that when you go on throughout the part and it's referring to an offence or offences, it's referring to an offence or offences in respect of which confiscation is sought.
Or a potential confiscation at least, and in fact, and no doubt in respect of which subsection 3 means that one will actually be sought, is actually being sought, yes.
And that, of course, I suggest is supported by Article 4 of the transitional provisions, which are 1139, which, when they talk about Section 156 of the Act, the brackets telling you what they're talking about, the making of a confiscation order. So it's limited to situations where there's a making of a confiscation order, that it shall not have effect where the offence. So when the confiscation order is made, was the question that the court might ask, this is quite a simple way of looking at it, is when the confiscation order was made in this case, in these two cases, if it was one offence, was it committed before the 24th of March 2003? Answer, no. Were any of the offences in respect of which the confiscation order was made committed before the 24th of March 2003? The answer is no. So nothing incorrect has been done when one actually breaks it down to its most simple form. So to maybe finish on this point, my Lord, what I'd say is that the focus of the legislation is to enable confiscation proceedings to be conducted in relation to offences that merit such proceedings and which qualify for them, so that an offence or offences at all times just means an offence or offences in respect of which confiscation is brought, because at all times at which reference is made to an offence or offences, that is exactly what is happening. We'll move on, my lords, then to the argument can become quite circular sometimes when one sort of tries to condense it, but I was going to move on then just to look at section 218, which has been referred to by my learned friend. At page 1041. And this, I suggest, is also supportive of the respondent's contention and is against the appellants. Break it down a little bit. The section applies if a defendant is convicted of an offence by a magistrate's court. So it's triggered by conviction for only one offence, potentially, and the prosecutor asks the court to commit the defendant to the Crown Court with a view to a confiscation order being considered under section 156. And in such a case, the magistrate's court must commit the defendant to the Crown Court in respect of the offence and may commit him into the Crown Court in respect of any other offence falling within subsection 3. So, to stop there, the appellant has accepted, and rightly accepted, that the magistrate can, or the prosecutor can limit the number of offences in respect of which the magistrate is being asked to commit the defendant to the Crown Court. When the prosecutor asks the magistrate's court to commit the offence for the purposes of confiscation, the magistrate's court then must commit the defendant to the Crown Court in respect of that offence. In other words, that he's then dealt with in the Crown Court for confiscation and for sentencing. But 2B means is that it may also commit to the Crown Court in respect of the other offences which have not been asked to be committed for confiscation, so that they can be dealt with globally from a sentencing point of view. And that's the reason for 2182B.
But he can't commit under 2182B for the purpose of having those offences taken into consideration in relation to confiscation.
No, they would not be taken into account for confiscation. They would be dealt with separately for sentence. And then, if one reads on to section 219, if a defendant, yes, it's 219 says, if a defence committed to the Crown Court under section 218 in respect of an offence or offences, this section applies. So, go back to section 1569, the offence or offences mean the offence or offences within 156, and clearly have the narrow meaning of the offence or offences in respect of which confiscation is sought, not the wider expansive suggestion that they're all the convictions, because offence or offences have the same meaning throughout, and it's clear that the prosecutor can limit the number of offences which are in fact sent up to the magistrate's court. So
what happened, just as a matter of interest, going back a step, what do you say happens if in fact under section 156 2 and 3 the prosecutor gets a conviction for a lot of offences and asks to proceed under the statute, and some of the offences are or one of them is pre-24th of March 2003. What would the court do there? Do you say it then simply says, or should say, it's not appropriate to deal with that? And if so, the pre-24th of March 2003 offences, or what? Because if it starts to deal with them, then transitional provision Article 4 seems to switch in and mean that nothing can be dealt with, or am I wrong?
Well, no, I suggest, my lord, it's actually more simple than that. If the prosecutor wrongly asks the court to proceed under both pre-2003 and post-2003 offences, the court would simply say, well, we can't make an order in respect of the pre-2003 offences, but the court can make an order in respect of the post-2003 orders, and any order would have to be limited to those.
Well, there are two categories of offences. There are what you, I think, have described as the confiscation offences.
Yes.
And they're dealt with under 218, 1 and 2A.
Yes.
But there's a second category of offences which are not confiscation offences, which are dealt with under 2182B.
Yes. That's absolutely right, my lord.
So, in answer to my lord, presumably what you say is the magistrate can refer both categories of offence, but when it comes to the Crown Court, It's only the first category that the Crown Court can take its decision on.
Only the first category which confiscation proceedings
Yes.
can relate to. Yes, that's
Yes.
But you were being asked, I think,
Yes.
forget committal for a moment.
Exactly. I
Yes,
was
I
being
think Lord
asked.
Mance was asking.
I was being asked what all happens in conviction before the Crown Court.
The convict, two types of conviction.
Is it right, Mr. Donald, that the effect of 156 is that one is making a confiscation order in respect of offences at all? You are making a confiscation order, the alternative argument runs, I suspect, in respect of a defendant who has benefited. But it's, your confiscation order isn't linked, or is it, to a particular offence?
Well, no, it is linked to an offence because if there are two, it can be made in respect of general criminal conduct or particular criminal conduct.
If it's lifestyle, it'll be
If it's lifestyle, it might be a rings open, but one has to get to lifestyle first through the prism of the offences of which he's been convicted.
Yep.
And that's where that becomes relevant. For particular conduct, it's limited to conduct which constitutes the offence or offences concerned, or it's conduct which constitutes offence of which he was convicted in the same proceedings as those in which he was convicted of offence or offences concerned, or it's conduct which constitutes offences which the court will be taking into consideration in deciding his sentence for the offence or offences concerned. So the order in particular conduct is limited to benefit from the actual offences before the court or ones that have been taken into consideration. Okay. That all have to post-date 2003.
Now, you're looking at 2243.
Yes.
Which is the non-lifestyle.
That's non-lifestyle.
That's so you're interested only because of section 156. 4.
Yes.
Interested only in his particular criminal conduct.
Yes.
And here is the section 2243, which tells you what particular criminal conduct means. Easy enough if it's the offence or offences concerned, that's A. Fairly easy if it's TIC's C. And what do you say is within B?
Those are offences that confiscation proceedings have not been sought or the court has not carried out a hearing in relation to. There must be.
Well, you in order, if you're applying 2243, you are in the process of the confiscation hearing, aren't you?
Yes, absolutely.
That's what you're doing. And what are you looking for? We've worked. You've told us what you think A is and C is, and they're maybe fairly straightforward. But what's B?
But B are, as I say, they must be offences which form part of the convictions, but are not offences in respect of which the prosecution has asked the court to proceed, or the court has felt it is appropriate to proceed. Possibly because the amount was so small, or possibly there might have been elements of proof that were absent, or perhaps the prospects of recovering benefit was not great. There could be all sorts of reasons why.
But there must be post-March 2003.
They must be as well, and that's also called need in the written submission.
And you say, I think, that the same proceedings means proceedings in the Crown Court, don't you?
Well,
because you took us back to
that's right. Well,
156 for that proposition some time ago.
156 only deals with proceedings in the Crown Court.
Right. So what on earth are these?
Well, as they are proceedings that have not, which the court has not decided to. It's appropriate to deal with as confiscation cases.
But then come 2243, you are dealing with them.
So that can be taken into account as particular criminal conduct, but it's not necessarily the subject of the confiscation proceedings. It's part of the, might I say, imaginative draftsmanship of this legislation.
That may be the answer.
Why do you say they have to be in 3B? They have to be post 2000.
Article 9
is Article 9, so
yeah.
It requires the transitional provisions.
Yes, Article 9 says conduct which constitutes an offence was committed before the 24th of March is not particular criminal conduct under section 2243 of the Act. So,
but the significance of it is that as far as the primary legislation is concerned, the expression, the offence or offences concerned isn't exhaustive of all the offences of which the person was convicted in the proceedings before the Crown Court. If one grants the assumption, which Mr. MacDonald denies, that B extends to proceedings in the Crown Court as well as Magistrates' Court.
Yeah.
But in my submission, it must apply to the Crown Court. Query whether it would apply to the Magistrates' Court, but
Well, I think in the proceedings in which he was convicted in 223(3), I think must include the Magistrates' Court, mustn't it?
223C.
No, 223 subsection 3.
Yes.
Yeah, 3A.
I think
3A.
I think that is right.
Yeah, 3A.
So presumably it does also in 224(3)(b then,
Yes,
same
I
sort
think,
of phrase.
that is right.
But it doesn't mean, say, it necessarily has much impact in relation to proceedings in the Crown Court. Because it may be that it covers them technically and linguistically, but doesn't impact them.
Well, the draftsman obviously thought that there were going to be offences of which you were convicted in the same proceedings, including in the Crown Court, which were not offence or offences concerned.
Well, one very
Whatever
good
they are, he must have thought there were some.
Well, not necessarily in the Crown Court. I mean, he might have just been dealing with the Magistrates' Court. That's the argument,
I see.
think.
well, one very obvious type of offence of which he would be convicted in respect of which confiscation proceedings were not initiated would be pre-2003 offences, which would have been convictions on the same indictment, and Article 9 is then needed to make sure that they're not taken into account.
But absent Article 9, they would be within the primary legislation. That's the point. Yeah.
Yeah, they'd be within Section 156, wouldn't they? So you wouldn't need, again, it'd leave open what 2243B is attacking. Right. That's particular criminal conduct. What about criminal lifestyle? Is there anything to say on that?
Yes, the other part of Section 218 that I was calling an aid is 218(4), which also talks of a committal being made. That's at page 1041, my lords and my lady. That also talks of a committal being made in respect of an offence or offences. And it must be the narrow meaning of an offence or offences being less than the totality of the convictions which the defendant has faced.
Yeah.
So, anything further on 218, my lords, those are my submissions about that particular aspect of the matter. I have dealt with Article 8, my lords, and that would have been the next topic on my agenda on the original plan, but I don't think I need to go back to that unless there's anything about it that my lords or my lady.
Well, you're going to give us a written...
Yes, there's going to be a written submission about that. Then if one goes to Article 9 and 224, which we've dealt with to some extent in the most recent exchange, I say that's also supportive of the prosecution position, because if my learned friend is correct, if the appellant's argument is correct, one would never get to a situation of having to consider 224(3) if all convictions were excluded if there had been a pre-2003 conviction. One would never have to get to the 224 Article 9 situation. Article 9 would be completely obsolete, with no effect, except possibly in the very narrow interpretation which my learned friend has urged upon your lordships about proceedings in the Magistrates' Court. But that point has, although I had fairly more detailed submissions about it, the point has, I think, been...
Or TICs, isn't it?
Sorry, my lord?
Or TICs, isn't it, as well?
Or TICs, exactly, yes.
Yes.
But the point I suggest has already been fully covered, and I don't want to weary the court by repeating.
You would need Article 9, wouldn't you, in any event, if you were to stop the court when considering particular criminal conduct under 2243, reaching the TICs that are pre.
Yes, you would need it for
commencement date.
TICs. There is a little bit of an anomaly in that, and I feel duty bound to bring it to the court's attention, that is 2243A would not seem to be needed to be covered by Article 9 because, no matter whose argument is right, because the offence or the offences will.
Well, certainly on your argument, if you are giving the connotation to the offence or offences concerned, the connotation that you do give to it, it doesn't seem necessary to have Article 9 in those circumstances.
But you remember from Article 8 that was also being excluded in Article 8 originally, but then the draftsman changed his mind and removed it, and I say the reason he removed it is because it wasn't necessary. And maybe there was an oversight in not removing it from this, but it's the same for even if the appellant's right, because if it was pre-2003, it wouldn't be, you wouldn't need to say again at 3A that it was, because Article 4 deals with that situation either way. Yeah. Either side of the argument between myself and my learned friend, Article 4 deals with the offence or offences concerned. So.
Well, it might just be belt and braces, I suppose.
Possibly. Yeah. So those are my submissions about the various interrelationship between the various parts of the sections. Just some general comments I would like to make. First one deals with one of the questions that my Lord Hughes asked, and that is that I say that if a conviction for an offence was committed before the 24th of March 2003 that was committed to the Crown Court from the Magistrates' Court, in addition to the post-2003 offences, it would not nullify the entirety of the proceedings. It would only mean that the court could not proceed in relation to the pre-2003 offence, or that any proceedings relating to pre-2003 would be of no effect.
Well, it would have to leave it out of account.
It would have to leave it out of account. Or if an order was made, it would be the order in relation to that offence would have no effect. And the same applies in relation to proceedings before the Crown Court. It is also significant, we say, that the assessment of particular conduct, which we've debated, is relevant also to the assessment of benefit in all confiscation proceedings, because I think it's the Mohib Jawad case, which is tab 21, page 1404 for my lords and my ladies' references, is a case that confirms that in assessing general conduct, one has to take into account also the particular conduct. So that test is always relevant. Further point of general application is that the appellant in its written case pleads prejudice resulting from the interpretation that I am arguing for, but I say that doesn't stand up to scrutiny. There's no prejudice to the appellants. If they had not been coincidentally prosecuted for pre-2003 offences, they would have been subject to the full rigours of the 2003 Act, despite the earlier wrongdoing. But if the appellants are correct, they are, in my submission, the recipients of a very fortunate windfall. That is, that if the respondent is correct, they are not entitled to that windfall, and that cannot be described as a jeopardy or prejudice. It's simply a fact of life, and they're no worse off than if they'd been dealt with separately. And indeed, that very point is dealt with in Stapleton at tab 36, page 1682, paragraph 8. Also, and some of these have been touched on again, one has to consider the practical issues if the appellants are correct. One practical issue would be if there was a minor conviction or an assault that we've discussed before, pre-2003, that could condemn a much larger and more serious number of convictions to be dealt with by earlier legislation, despite the fact that if prosecuted only for the pre-2003 offence, they would be governed by the 2003 Act, which I suggest would be a very unattractive result. Also, one could have a situation where the court could be rewarding a defendant for greater offending than someone guilty of lesser offending. An example would be someone is convicted of 3 fairly modest confiscation type proceedings after 2003, fall to be dealt with under the 2003 Act. Another person is convicted of 1 minor offence pre-2003 and 10 serious offences post-2003, and yet he would get the benefit, if there is any benefit of it, of the earlier legislation. And that also, I suggest, is a very unattractive proposition. Also, a conviction pre-2003 in respect of which there was no benefit at all could lead to all post-2003 convictions falling to be dealt with under previous legislation, which cannot have been the purpose of Parliament. There is also the problem identified in Simpson at tab 34, paragraph 19, that the determination of which regime would be used, and that's what Simpson's saying. I take issue with my learned friend suggesting that Simpson has got all the facts wrong. All Simpson was saying is that someone being acquitted determining the regime which would be used would be absurd. So that the problem was identified as that the determination of the regime should not be determined by whether a person was convicted or acquitted of a pre-2003 offence. The other point that has been debated, I don't want to labour it, and it's dealt with in Molden, as my learned friend has pointed out at page 1481, tab 27, is that it might encourage prosecutors to pursue offences under 2 indictments to avoid the situation arising. And I say once again, that cannot have been the purpose of Parliament. Parliament would hardly want to encourage more trials than are necessary in a court system that is already overburdened. And finally, it might encourage the prosecutor not to prosecute a perfectly legitimate prosecution pre-2003 if it jeopardised the possibility of confiscation proceedings being brought subsequent to the proceeds of crime 2002. So we say it could hardly have been Parliament's purpose to deter prosecutions of offences where evidence existed that a crime had been committed. There's another situation by which it could be avoided by the prosecution, which is equally unattractive, and that is the prosecution could pursue a prosecution for post-2003 offences in the first instance, complete those proceedings, and then return to the pre-2003 offences and have a separate prosecution for those, there being no statute of limitations in the criminal statute book.
Do you know how that's dealt with if, in the course of the first set of proceedings, criminal lifestyle is established which embraces the subject matter of the earlier offences? I suppose at that stage there won't have been convictions, but supposing that there have been convictions, separate convictions in respect of the earlier offences, so you know they've been committed, how is an overlap avoided, how duplication? Because you're going to, under the earlier offences, you're going to have another regime applied, and no doubt you'll be looking at least the gain from the earlier offences, but it may also be taken into account as part of the criminal lifestyle under the later regime.
Well, that in theory, my lord, is absolutely correct, but in practice would not occur because courts will always apply the general principle that someone shouldn't be subject to double jeopardy, right, shouldn't have to pay twice, and the regimes could easily take into account what way it's been dealt with. If everything was dealt with under the 2000, if everything post-2003 was dealt with under the 2002 Act, then unless it was not a criminal lifestyle case, one wouldn't have to go back to deal with the pre-2003 offences because they could be taken into account when a criminal lifestyle had been established. There would be no need for that regime at all. It would only apply if there was particular conduct, and in my submission, and then one couldn't go back to the pre-2003 under the Act, so that it would have to be dealt with under a separate regime if the prosecutor wanted it to. So there would be, in effect, no overlap.
Sorry, what was the position again if it was a criminal lifestyle?
If it's particular criminal conduct.
No, I've got that. What would it be if it was a criminal lifestyle?
Criminal lifestyle under section 2242,
yeah,
all of the offences that were ever committed can be taken into account.
Right.
Therefore, there wouldn't be any need for the prosecutor to embark on a pre-2003 regime.
I
Like
see.
the pre-2003
Yes, I see. So you
offence.
Sure, you're right about that, but on the other hand, there have been cases in which
Prosecutors try to do that.
effectively people have been at risk of double recovery, haven't they? But there are some provisions in POCA, aren't there, which are geared to preventing it. Not very many, not perhaps as many as there should be, but there are provisions somewhere which deal with taking out of account
Well, certainly when discounts
where previous confiscation orders have been made.
but certainly,
I'll put my hand on them.
certainly, if there's compensation order, that's discounted, for example.
Yes.
Be able to go back. Not all of the Act is included in the
No.
in the material before my lords. I'm just trying to remember myself. There is, maybe in the English part of the Act which has been copied. I do think my lord is right, but I'm not sure exactly in what respect. Junior's trying to see if she can find it online. And maybe while she's doing that, I'll just maybe move on to another point, a small point, and that's to deal with Dr. Thomas and his articles. I'm not going to deal with them in any great detail. Obviously, just like the CPS, Dr. Thomas's views are not binding on this court. Coming back to the earlier advice issued by the CPS. But Dr. Thomas, in my submission, his criticisms were ill-founded because really in relation to the post-2003 order and 2002 Act, which is the only one that this court is concerned with, he deals with those as page 1751. He has in fact misunderstood the import of the legislation. The top of page 1751, beginning, sorry, at the bottom of page 1750. Section 76 of the Proceeds of Crime Act 2002 provide, that's the English equivalent, provides the defence particular criminal conduct is all of the defendant's criminal conduct which constitutes the offence or the offence is concerned, and conduct which constitutes offences of which he was convicted in the same proceedings as those in which he was convicted of the offence or offence is concerned, and other offences which would be taken into consideration. There appears to be no provision under which the judge can ignore any particular offence for which the offender is before the court at the time the confiscation order is made, whether or not the prosecution rely on that offence. Well, that's clearly wrong, because Article 9 makes it clear that pre-2003 offences cannot be taken into account in relation to that assessment. So it does not get, as he thought, the pre-2003 offences in by the back door. And I've already at length debated the situation in Article 8.
I mean, in fact, your position is precisely the converse of what Dr. Thomas. Your position is that the court may not take them into account.
They cannot. They are not permitted to take them into account. It's prohibited. He also then says that the court may proceed towards confiscation in the absence of application by the prosecutor if the court believes it appropriate to do so. And he asks, is the judge entitled to proceed towards confiscation on the basis of only certain counts of the indictment would be considered? Absolutely yes. Why would he not be? For so many different reasons, which we've already, I hope, exhausted. And I don't intend to try and exhaust them any further. Yes, I think it's 158 was the section that deals with other confiscation orders. Then at 1583, Subsection 4 applies if the conduct concerns general criminal conduct. Confiscation order mentioned subsection 5 has at an earlier time been made. Its benefit for the purpose of that order is benefit from its general criminal conduct. 4 is its benefit found at the time the last confiscation order mentioned in subsection 3C was made against and must be taken for the purposes of this section to be his benefit from his general criminal conduct at that time. So it seems that it's being left out of account.
Yeah, that's what I had in mind.
Yes.
And it's under a general heading, benefit. If we got that section, we probably have.
Yes, it's 158, sorry, my lord, it's page 988 of the paper.
Thank you. That's the English provision, but
That's
there is.
the Northern Ireland.
That's Northern Ireland.
That's a qualifying provision to 156.
Oh, right.
So
Yeah.
that would complete my submissions, my lords, on the first submission and primary submission that and the interpretation is allowed the prosecution to do as it did in this case. If that submission is correct, there's no need to consider the argument based on the previous case law. Essentially, what we say is the previous case law was correct for the wrong reason. I suppose that's our primary argument. But in the second submission, the court has our written submissions. And unless there's anything further about those that the court would like to deal with, I did not propose to say anything further about it. And the final fallback position is only relevant as the court is against me on both the first submissions, and that is whether the error, if it was an error, is a technical or substantive one, but I really have already dealt with that. So unless the court would like me to address any other further particular issue, those would be my submissions.
Do you want to say anything about what the court's powers are if you're wrong?
But I think that the concession was made by the prosecution, and I wouldn't seek to go behind it. It was before I was in the case, but
No.
I certainly wouldn't seek to go behind it.
Understand that.
I think in certain circumstances the court could make a substituted order. However, there would be difficulties with it because
Certainly it would be very difficult in Ms. McCool's case, wouldn't it?
it would be.
Yes.
It would be impossible in Mr. McCool's case, but the concession is made in any event.
Yeah.
But in any other case, I envisage that there could be difficulties because this goes to the very heart of the court's jurisdiction. If the court had no jurisdiction, how could anything else be fitted in behind it? I can see an argument, well, you just substitute one act for the other and that will reinstate the jurisdiction, but it becomes quite a difficult topic. And it was something, possibly that's why the concession was made. So,
Yes, maybe.
so yes, thank you for that, my lords.
Can I just ask you, we've spoken quite a lot about section 2243B, and goodness knows that is difficult enough. I wonder if you have anything to say about 2233A. I'm asking about that one particularly because it's envisaging that the defendant, as well as being convicted of the offence or offences concerned, that's the ones referred to in section 1562, he has also been convicted of other offences constituting conduct from which he has benefited. So
Yes.
that's not robbery plus assault. This is robbery plus some other gainful form of criminal activity.
Well, this is 2233 is dealing with the definition of conduct which forms part of a course of criminal activity,
Yep.
not the definition of offence or offences. So it's limiting, it's just saying when something would qualify under 2232B, and one qualifies for 222B if there's an offence or any of the offences is conduct that forms part of a course of criminal activity. So 223A, while it's a little bit cumbersomely worded, is actually dealing with 3 or more offences, meaning the offences concerned.
No, it's not, because it's talking about 3 or 4 more other offences. Well, and if you ask other than what,
Yes, but
it's got to be other than the offence or any of the offences concerned.
Well, it's not a particularly well drafted part of the section, but if we come back to this, my lord,
Yeah.
sorry, what is looking at is what criminal activity, what conduct forms part of a course of criminal activity. It's the definition of what conduct forms part of a course of criminal activity. That conduct being that the offence or the offences satisfy the test of conduct forming part of a course of criminal activity. And the offence or offences form part of a course of criminal activity if in the proceedings in which he was convicted of 3 or more other offences, each of 3 or more of them constituting conduct from which he has benefited.
Is this it? It's aimed, isn't it, at repetitive offenders?
Yes.
And repetitive offenders are those who've done it 4 times or more, or
Well,
done
it's
some,
three-
or
three-
done
three
some,
or
or
more.
done something 4
But that
times.
includes the offence or the offences concerned. It's not.
Yes, quite.
It does include those in my submission. So,
Well, the 3, no, it must be at least one offence concerned, which is part of a course of criminal
Yes,
activity,
plus
which
others.
consists of 3 or more others.
yes, that I think is
Associated with.
So it can't be the offence or offences concerned to which subsection 2 applies.
I just wonder why there is any reason. Why, you see, you start with 223, 2231. When is there a criminal lifestyle? 2, when the offence or any is not only specified and was committed over a period, or was committed over a period of 6 months, or it's or, isn't it? Or is it and?
No, I think it's
No,
the and.
It's and. It's and. So it must constitute part or form part of the course of criminal activity. When does it do that? When there are in total 4 offences.
yes. That might be.
Wow, it's very odd. I mean, criminal activity, what sort of offences are committed over a period of at least 6 months? I suppose many, but why is that a criterion? It's a very odd criterion, isn't it?
But further assistance can be gleaned from 3B. Because 3B is a course of criminal activity if in the period of 6 years ending with the day when those proceedings were started, he was convicted on at least 2 separate occasions of an offence constituting conduct from which he has benefited, and that must be talking about the offence or offences concerned, going back to 2B. Has to be because
Why?
2B is focusing on conduct which is the offence or the offences, which forms a part of a course of criminal activity.
No.
Then when it's
Well,
defined-
it's not the offences concerned. This is surely by definition saying, as long as you've got an offence or offences concerned,
Yeah.
you can look at that in conjunction with any old random offence you can find in the last 6 years on any old separate occasion, as long as there are 2 of them, and from which he's benefited.
Yes.
So it doesn't have to be. B is definitely not one of the offences concerned,
No.
or 2 of them.
Well, no, probably not. But would it make any difference if 3A had said, after the first line, convicted of 3 or more other offences concerned?
In my submission, there wouldn't have been any difference.
I just wonder about that.
Well,
But it may not. I mean,
no, because if it were 3 other offences concerned, it would automatically fall within 2, because it says the offence or any of the
No,
offences,
it wouldn't.
wouldn't it? Oh, because it might not have been
You've got
convicted
to have
over...
4. You've got to have
Yes.
4 of them, otherwise you don't get off the ground for Leicester.
Yes, and anyway, the other ones might not have been committed over a 6 month period of at least 6 months, so they might not satisfy that.
Yeah.
And they might not fit in with section 5, I suppose. Schedule 5.
But the point is, if we take an example, just to make the matter even a bit more complicated, if we take an example of someone who is convicted of 10 offences that are caught by confiscation and none others, then if one confines 223A to other proceedings, then he can never be guilty of a criminal lifestyle, and that can't be the purpose of the legislation.
No,
Because conduct forming part of course of activity is defined by section 2233, and in my submission must include also the offence or offences concerned.
yeah, I mean, the whole point is it's the same proceedings.
Exactly.
Yeah. And other simply means not satisfying the criteria in subsection 2.
Exactly.
Yeah, and the criteria in subsection 2, be it noted, are alternatives. You get that from any in the first line of
yes.
subparagraph 2.
Yes, I see.
So it doesn't have to be 6. It's either Schedule 5,
Yes, I see.
etc.
Yeah,
That I suggest, my lord, is the answer.
yeah.
That's of some assistance to my lord.
Well done.
Yes, thank you.
Equivalent
Sit down because Donald seemed to be getting up. It'll be 2 minutes after he sat down. Those are my submissions, my lord. Lady.
Thank you very much. Yes, Ms Walsh.
Well, just dealing with that last point, I think Mr McCollum and I would be in agreement in relation to the construction of section 223 3A in relation to other offences, and I think the explanation is that it should be approached in this way. The condition, looking at 2232, the condition is that the offence or any of the offences concerned satisfies any of these tests. Now, I think one proceeds on the basis that if there's one offence that satisfies any of these tests, in other words, that it's specified or constitutes conduct forming part of a course of criminal activity, then you can take into account other offences that may also be offences concerned. Because conduct forms part of a course of criminal activity if the defendant has benefited from the conduct. That's the conduct from the one offence, taken for the sake of example. And in the proceedings in which he's convicted of 3 or more other offences, which would include other offences that are offences concerned.
Yeah.
Right.
Yeah, I think we've got
That
there,
means,
yes.
yes, so as long as, if you start with one and
Yeah.
it meets the criteria,
There's a
there
narrow-
could be others that don't
narrower
have to
bracket
not meet the
for
criteria.
one.
The others could also meet the criteria,
Yeah.
probably would meet the criteria, or one of
They
one
might
of
or they might not.
Yes.
Yeah, the thing that matters is that they've generated benefit.
Yeah.
That's
Yes.
the last words of A.
The focus is on, an individual offence. And then, and of course, that they're not limited to the concerned or other offences in the sense that they could be other offences that are, for example, left behind in the magistrate's court that don't get to the
Right.
Crown Court for some reason. In relation to Article 8, my learned friend will be providing a written submission in relation to that, and I would be grateful for the opportunity in due course then to reply in writing to that submission when we see it.
Well, I think he's going to do it pretty quickly, and we could ask you to do it within how long after that?
Say a week. Say a week, my lord.
Well, it's quite long, but I gather it's almost ready, yours, Mr. McCollum.
Hopefully, everyone should have it by this afternoon. So then,
You think you might do it by Wednesday next week, close of play?
Well, yes, sir. That's the direction, my lord. We'll do that. Learned friend then deals with 156 and says this 156.2 is only applicable if, in fact, an order is sought. This obviously is crucial. The definition in 1569 is that it references anywhere in the part. This is supported by section 236. References in the part 2 that the offence or the offences concerned are to the offence or offences mentioned in subsection 2. They are not references to offences which are provisionally confiscatable offences in some way, or which provisionally can be regarded as offences that will meet the thresholds, will comply with the criteria. These are references only to the offences that appear in section 1562. Which is the first condition at the very commencement of the entire process. And the first condition is simply that the defendant, and the focus is on the defendant, falls within these categories, namely that he's convicted of an offence in proceeding before the Crown Court, or he's committed to the Crown Court under 218. Those are the offences concerned. Far from being narrow and limited to confiscatable offences in some kind, they are broad. They're all the offences of which he's committed. That's the first step. And then having met that first step, the court goes on to consider the other steps. It begs the question to suggest that the section 1569 definition really refers to not just section 1562 cases, which is what it says, but section 1562 cases that have an extra quality, which is that an order is sought, or it could be sought, or it falls within the category of confiscatable offences. That defeats the purpose, in our respectful submission, of the definition. That's crucial.
Where else do we find the phrase offence is concerned? We do find it somewhere, don't we? In section 224, I think. And where else?
Oh, lots.
It's,
I mean,
but specifically,
it's rather odd in the other places, and as a definition, if offence is concerned refers to something which doesn't actually have any relevance to the confiscation proceedings, or am I?
1055 is where section 236 appears.
236. Yes. Yeah, that's the definition, yeah.
165. One and two. One, in fact, throughout, I think. Certainly 1, 2, and 3.
Section 100.
Section 165.
Yes.
But on your theory, in 1562A, it could be assault. That could be the offence.
It could be
It
theoretically.
could be assault, and that might be the only one. And then the prosecutor might, for some bizarre reason, ask the court to proceed, and the court must, under the provisions, even though the assault is not going to produce anything. The subsequent process will be very quick.
The court wouldn't believe it was appropriate, would it?
It doesn't have to.
It doesn't have to, it's an or.
Yes, I see, yeah.
And
Well,
the
first of all-
point about if I can just add on to it, the point about 1569 is that it's dictating what meaning of offence or offence is concerned is going to be used in the whole of this part, and the whole of this part is about confiscation and allied topics.
Yes.
So on this idea, it's assault.
It could be. Of course, the process would be quick if that's all that's there. But of course, there are, even an assault, it's conceivable that there could be a benefit. In some, if, for example, the assailant is someone who regularly assaults other people and paid to do it, he derives benefit from it.
Yeah. Well, absent that somewhat imaginative possibility.
Well, you could, for example, have somebody who makes a habit of recently assaulting his employees, for example. Just might, for example, be a film director or something of that kind. And if he is convicted of assault in proceedings before the Crown Court, he might be found to have a criminal lifestyle on the basis that the offence satisfied the test that it constituted conduct forming part of a course of criminal activity, if he's in the habit of doing this.
Yes, Martin?
Now, does that not then open the door to an inquiry into or the possibility of making a confiscation order?
The reality is that it's unlikely that either the prosecutor would ask for this to be done or the court would consider it appropriate unless it's a confiscatable type of offence. But that's not the same as saying that section 1562 is limited to those kinds of offences, because it does beg the question, the ultimate question.
Well, I think you might also say, imagine not, that if it was a case of a single episode of assault, completely unrelated to any benefit at all, it would be an abusive process for the prosecutor to ask the court.
Yes, pointless use of the process.
You've got to be a bit careful about abuse of process. But the short answer is, isn't it, that if you had such a case, you're in section 156, and the judge would say, well, "You mean that, do you, Mr. So-and-so?" And having got the answer yes,
he would say, right, section 1564, there is no benefit. Now go home.
That's why it would be a quick inquiry.
Yeah.
Get very far.
Yeah.
Yeah.
So, I mean, it's a fanciful example. The point is, 1562 provides a very low threshold for the start of an inquiry, and then other conditions have to be met before a confiscation order is going to be made. But it seems wrong in principle to suggest that the definition in section 1569 that relates to 1562 should somehow incorporate elements of the other conditions or criteria that have to be satisfied before a compensation order is made. And that's what the prosecution case amounts to,
You have got
at least on a provisional basis.
I mean, can I just take up Lady Black's point that this expression, offences concerned, is defined only for the purpose of a whole raft of provisions which are to do with confiscation.
Yes, ma'am.
It has no other purpose. And for example, if you get to 165, you run into all sorts of restrictions on what you can do by way of sentence
Yes, ma'am.
for any of the offences concerned. 165(1). If the court postpones proceedings under 156, so supposing you've got some offences which are financial, and you've got therefore the prospect of some kind of benefit being discovered
Yes.
at the end, and you don't deal with it straight away, and I don't know what the practice is in Northern Ireland, but certainly in England these days, confiscation is hardly ever dealt with straight away.
Well, that's the same in Northern Ireland.
Quite. And then, if you're sentencing under 165, yes, you may proceed to sentence. There's no problem if you're going to lock him up. But there are lots of things you can't do. You can't fine him, 165(2)(a). You can't, referring back to 163(3), make a compensation order or an order under the Misuse of Drugs Act, forfeiting the drugs, deprivation orders, taking away the motor car he was driving, and so on. That may be the necessary consequence, but it is, on the face of it at least, inconvenient.
Yes, it may very well be.
Yeah. Whereas if it were so, that offence concerned meant those where there was an active prospect of a confiscation order, as it were, generated by them, then those restrictions might just have to be accepted.
Well, even that formulation with respect, my Lord, identifies the problem here, that once you start
How do you
considering
define it?
how to qualify this provision,
Yep.
you embark on a process of legislation, essentially, rather than interpretation of the words that are actually
Okay.
in the Act itself. But this is an area, obviously, where it is sometimes difficult to see the wood for the trees. It's my respectful submission that the court should properly focus on the wood here, which is section 156, but for present purposes, it is Article 4. The critical provision, as my Lord Reid said earlier. And looking at Article 4 for the last time, it simply says section 156 shall not have effect where the offence or any of the offences mentioned in 1562 was committed before 24th March 2003. It is the simple, normal interpretation of that sentence that should dictate the meaning of that sentence, rather than the kind of convoluted examination of all the peripheral provisions that we have been embarked upon for the last 2 or 3 hours, and in fact 2 or 3 years over the course of the proceedings. This, in our respectful submission, is a simple case. One stands back and looks at the essential provisions. It only becomes complicated if one embarks on examination of the kind of minutiae in the primary and secondary legislation which can make it complicated, unnecessarily complicated, that doesn't actually affect the meaning of this provision. That's in those circumstances that I respectfully suggest that it's not particularly profitable for me to revisit some of the points that we've already made extensively, both in writing and orally. And if I could just have one moment. Unless there are any other matters in which I can assist them.
I mean, Article 4 can't be detached from the proper meaning of Section 156(2), can it?
That's right.
So, I mean,
But again, Article 1562 has to be read, given its ordinary natural
Yes, well, we've
and
got
again,
that,
it's
yeah.
a sentence which has an obvious meaning, which corresponds with the meaning that we respectfully attach to it. And it's only if one starts inserting words, qualifying it, devising additional criteria to apply to it, incorporating criteria that it really are applied for other purposes at subsequent stages of the entire process, that one gets into difficulty. One doesn't need to do that. Those are my submissions.
very helpful. No, thank you very much indeed. Well, the court's grateful to counsel for their submissions and looks forward to the written additions and will reserve its judgment.